We'll continue our discussion on the lands. I'm going to focus on this topic because most of the problems in the rural area is all about dispute on lands. Okay, so and there are only few people who knows the basic knowledge on lands. Okay, so last time I discussed about the kinds of lands. Okay, what are those lands owned by public and what are those lands owned by private. Okay, so you may ask what, or probably some of you met the word already, regalian doctrine. Okay, what is a regalian doctrine? It's a time-honored constitutional precept that all lands of public domain belong to the state. Okay, that is the general rule. Okay, which means that if there are conflict as to the ownership, or if it cannot be proven that it is owned by private individual, the presumption is that it is owned by government under that principle. What do you call it? Regalian doctrine. Okay, so now we go into the classification of public lands. Now, the classification of public lands is an exclusive prerogative of the executive department. Remember that. It is an exclusive prerogative of the executive departments. Now, it may be converted, lands later on may be converted into other kinds of lands. Okay? But there are specific lands that cannot be converted by which government? The DENR. It's the DENR. The DENR is in charge of the classification of lands. In fact, they are the one who is in authority to determine whether the land is alienable and disposable lands. So it is within the executive department. What do you mean by annus probandi or onus probandi? Okay, lies on the person applying for the registration that the land subject for application is alienable. Okay, so it is the burden of proof of the one who files for registration of public land that the land that he is applying is a public land or alienable land. Okay, there are classifications of lands. Although it may be public, but it cannot be alienable, or it's called inalienable, or it cannot be disposed. Meaning it remains to be an ownership of government. So what are these? Natural parks, okay, and mineral lands. Those are the only lands that cannot be reclassified. In fact, it is not within the power of the DENR. Other lands can even be reclassified. So it is when there are conflicts between the local government, sometimes they refer it to the DENR. Take it from me, I had an experience on that, and we had a case, in fact, about to be a case, but they refer the matter to be to be decided by the DENR. However, the DENR was in our favor. So it is the duty of the DENR, because the DENR has the map of the ownership of all lands. But what are the requirements? Okay, so it must be a Filipino citizen. Why? The lands in the Philippines is always tended to all Filipinos. In fact, there was a provision before of changing our constitution, making it 60-40. Okay, and even goes higher to the extent that it should be rationalized. Okay, I was there during that proposed amendment or revision of the constitution, but I oppose. Why? Because what will happen later on if foreigners can own properties? Okay, Philippines will be owned now by foreigners. Okay, they have the money, they can buy lands. So personally, I objected. And right now, the constitution was not amended. Okay? So there were 3 of us sent by the school to represent, okay, the academe, and I objected. Okay? So right now we remain to the sharing of 60-40. 60 ownership belongs to Filipinos, while foreigner may own up to 40%. It should not go lower than 60%. Why? Because as much as possible, the economy of the country must be controlled by Filipinos. So that's the reason why we have 60, and even in corporations, it's always 60-40. Because if they can own more than 60, they have the control. What if everybody, all the companies will withdraw? What will happen to our economy? We'll be bankrupt. So that is the reason why we have that law. It's 60-40, or foreigners are prohibited to buy land. In fact, when they get married, it is in the name of their wife. Okay? You check the foreigners, if you have neighbors there, whose property was registered. They cannot really buy property, except on personal property like condominium. But as to real property, house and lot, they cannot. It's in the name of their wife. Now, so the second on the registration, in case of corporation, such acquired private lands but not alienable and disposable of public agricultural lands. The test is to determine the corporation's nationality is based on citizenship of its stockholders. Corporations can actually buy properties, okay? But again, going back to that 60-40, the citizenship of that corporation must be at least 60%. Okay? So how will you know that it's 60%? You go into the nationality or citizenship. But the question there is, what's the difference between nationality and citizenship? What it refers here is nationality. Okay? Not based on citizenship. So what's the difference between nationality and citizenship? Nationality is the loyalty. Okay? Citizenship is where you born, okay, or where you take allegiance, or where you belong to a political body. If you are born in the Philippines, you are a Filipino, right? If you are born in America, even if your mother is a Filipino, you are an American, but you are also Filipino. You possess dual citizenship. Okay? Why? Because under Philippine laws, if one of your parents is a Filipino, you are a Filipino. Under the principle of jus sanguinis. Okay? Now, you may be born in United States, but you can become loyal, okay, to our country. So you may become a national, because nationality would refer to loyalty. Okay? But in general, when I say citizenship would refer to nationality. But there's actually a distinction there. It only refers to your allegiance when we speak of nationality. Okay? So do not be confused with that. You may be asked to distinguish nationality from citizenship. The best distinction is that it's on loyalty. Okay? But membership to a political body, it's called citizenship. Now, we go to the original registration of the property under PD 1529. Okay? The following persons may file in proper court, okay, of first instance. The court of first instance is now what we call as the regional trial court, on application of for registration of title of land, okay, whether personally or through the duly authorized representative. What they mean by is it really necessary to have a land that you own titled? Okay, it's not. The purpose of title, of course, it's one way to prove that you are the owner, but another way of proving that it is yours is the possession. If you possess the property for a long time, then that is yours, even if you don't have title. Okay? The title may be only used if you're going to sell it. You cannot sell a property without a title. But as to ownership, well, if you are in the position, you are the owner. You are the owner of the land. Okay? So, take note of that because, we don't know if you are in that position where you are possessing the property and yet you don't own it. You don't have a title. Okay? However, if there is really a real owner, like the land is titled and the title is not in your name, then it cannot be yours. It cannot be yours. But there's a prescription, 10 years and 20 and 30 years. 10 years, that does not apply to a titled land, however. This refers to a land that is not owned by a certain individual or it is not titled. 10 years if you are in good faith at the possession of the property, and 30 years if it is in bad faith. What is in good faith? You don't know who is the real owner. You believe in good faith that land that does not belong to anybody. So you have 10 years. If you stay there for 10 years, then that land belongs to you. If it is not titled. If it is in bad faith, you know that it may not be yours, but probably somebody or the right of the of the person who possesses or owns it waives it because it was not there anymore for a longer period of time. Okay, so 30 years. 30 years. So in the absence of any proof, then 30 years. Okay, if you do not own it, okay, but if you stay there for 30 years, the land may be awarded to you. Now, as to the award, which party that the government normally favors? The one who possesses. The one who possesses. Or, if you have a tax declaration, then you will be granted the better right. Why? Because the government needs money. If you are the one paying the tax, then probably there is a great tendency that it will be awarded to you. In fact, if you do not pay the real property tax, the land will be sequestered in favor of the government. Okay? Now, so who may apply? Those who by themselves or through their predecessors in interest. Okay? Maybe not you, but somebody who is interested, or maybe because he is an heir to the owner of the property. Okay? May apply. Okay? Have been in open, continuous, and exclusive, and notorious possession and occupation of alienable and disposable lands of public domain. Did you get it? Okay, so what's the keyword? Open, continuous, exclusive, notorious possession of an occupation of alienable and disposable lands of public domain. So take note of that. You can apply if you are in an open. What do you mean by open? Well, it's exclusive to you. Okay, everybody knows that you are the one. You live there for a longer period of time. Okay, and continuous. Okay, it's not interrupted. You stay there for a longer period. You don't go anywhere else. Okay, and exclusive. Nobody shares the ownership. Okay, and notorious. What do you mean by notorious? What is an opposite of notorious? A notorious president is the one who, what? Has a bad record. It's called notorious. Before we call president, this is recorded. Anyway, this is a classroom discussion. I have the academic freedom. Before, Ferdinand Marcos, notorious. And now, because of, passage of time, he's no longer notorious, but famous. Okay? In fact, his son became president. So he's now famous. So the opposite of notorious is famous. Okay? Now, so, and the land must be alienable and disposable. What are those lands which are alienable and disposable? What can you name? What are those classifications of lands? Okay, national park. Those are inalienable. mineral lands. Those are inalienable. It cannot be reclassified as alienable is possible by the DNR. Those are the only kinds of land that it cannot be classified. In fact, it's beyond the authority of the DNR to reclassify it. Other than that, is within the power of DNR to make it or classify it either into residential land, agricultural, commercial land, residential, commercial, agricultural, timberland, okay, or national parks. Okay, so it's again within the executive branch of the government. Okay, now how about in the case of like Cebu property? They reclaim it, and then these are actually part of inalienable. What are those inalienable and disposable land? Mangrove or timberland. Boracay, the entire island is declared before as timberland, and it cannot be titled, right? There are many now establishments there. They were able to title it. In fact, it reached the Supreme Court, and the court knew that it's a timberland. Okay, it's a the entire island, Boracay. Okay, so they have, it cannot be titled, but some of them have already title, okay, or tax declaration. Now, what do you mean by classification of lands? Okay, the classification of lands is what is what is found in the record of the DNR. Okay, like for example, that mountainous area there in Cebu City already starred with subdivisions and houses. Can you consider that as a residential land? Okay, no. What appears to be is not the real classification, because the real classification is what appears in the record of the DNR. Okay, even if it is denuded or let's say starred with several houses, it cannot be considered as residential if the classification is still timberland or other kinds. Okay, so what classifies the land is what appears in the record of the DNR. Okay, so it is not what appears to be, okay, what your eyes can see, but what the book says. Okay, that's the classification. Is it important to know its classification? Yes, it's very important. Why? In the classification, in the payment of tax, okay, in the increase of the value, like when a municipality became now a city, its value will be different. Okay, or if the land is situated in a zoning where it's near to a public road, that's very expensive. Unless or unlike to a land where it is bounded by other lands, okay, where there is no right of way. Okay, if it's bounded by other bodies or other lands, all you have to do is again to make access, a petition in court for road right of way. Okay, the nearer the estate, the nearer that it will be sacrificed. It is called the servant estate. The other one is called the dominant. Why dominant? Because you will be served by that property, but you have to pay. Okay, what's the principle that you can require a payment for that in any right of way? Basic principle of the Constitution: no private property shall be taken for public use without just compensation. Remember that, because in many instances, in many cases, in fact, in experience, some politicians do not know this one. They just take many private lands, construct roads to the extent that the owner was deprived. But the owner sometimes do not know. Unlike you know already because I taught you. You insist on your right. Okay? You say to them, no private property shall be taken for public use without just compensation. You will be paid. Okay? You will become rich if you know that right. If you don't know that right, you will, until your grave, you become a pauper. Okay, but if you know the rights, you can claim in government. Even those that are now no longer claimed a long time ago. Okay, you can reclaim it. Let's say for a long time that property was become a was sacrificed, or it was used by government without payment. You can claim it now. Okay, under the latest rule of the Supreme Court, in the term is reverse conversion. Reverse conversion. Okay, you can claim for damages or for payment if that property was not paid even for a long time. Okay. Now, so but what are the requirements for them to use the land? There must be an ordinance. There must be an ordinance. Okay. And what is the requirement to be a valid ordinance? There must be a what? Quorum. Okay, a petition by a certain legislator, okay, or a councilor that they are going to use the land. Okay, for public purpose. There must be hearing. And the hearing would include the stakeholders, the owner. If they did not summon you, okay, to attend a certain hearing for that project, that is invalid. Okay? Why? Because the local government code requires the attendance of the affected individual, affected owner. Okay? So if you think that it's really needed, well, there will be payment. Okay? And the payment is maybe in an installment, but a certain percentage will be paid to you. I think in local government is 15%. There's a difference between national government taking and local government. The national government takes position immediately. Payment may be later. What are those project of national government? DPWH project. Okay. But if it's only local, like the mayor or the governor, it's the requirement is different. Okay, so remember that those who have acquired ownership of private land by prescription under the provision of the existing laws. What did I say? Okay, if you possess it for 10 and 30, 10 years good faith, 30 years in bad faith. Those who have acquired ownership of private lands or abandoned riverbeds by right of accession or accretion under the existing laws. What do you mean by abandoned riverbed? Abandoned riverbed. Let's say in the course for a long time the river was there, traversing the same body of land, but because of a typhoon, it moved and transferred to your property. Okay? Where is your property now? Lost, right? So what will you do? That riverbed that was abandoned by the new course now, that's yours. That is yours. That is yours now. Okay? So that's your property now. So, well, the problem is that you may be in conflict with others because they would say that's government. But no, you can claim it. It's yours. It's yours. Okay? It's your property. It's your property. Right.